I'm going to call this meeting to order. So my name is Monica Schmucker. I am the special magistrate to hear today's hearing. Sorry, I have this letting me know I'm supposed to be here. I'm a licensed attorney in good standing with the Florida Bar. I'm qualified to serve as the appointed special magistrate for the town of Fort Myers Beach. At this time, if everyone can please silence their cell phones or put them on Do Not Disturb. This is a quasi-judicial hearing, which means it's similar to a case in court. However, the rules are less formal. Formal rules of evidence don't apply, but fundamental due process will govern today's proceedings. All parties who are here to speak on a case will have a chance to do so. And then within 15 days of this hearing, I'll issue an order with findings and facts, conclusions of law, and affording the proper relief consistent with the code and Florida law. At this time, I'd like everybody who is going to testify today to please stand up, raise your right hand. Do you swear or affirm that the testimony you are about to receive is the truth, the whole truth, and nothing but the truth?
I do, yes.
I'm sorry. Do you swear or affirm that the testimony you are about to provide in today's hearings is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right, we have only one case I see on the agenda. And it's it's 80 Avenue E, is that correct?
Yes,
All right, can the town go ahead and proceed?
Real quick, Your Honor, if I may.
You need to be on microphone.
I do have a jurisdictional argument to raise. I'm happy to wait until the town's concluded to make that presentation, or if you want me to go ahead and get that done first, however you'd like to do it, but because it's jurisdictional, I wanted to get that out there.
Well, I need to know what they're presenting first in order to be able to consider the jurisdictional argument.
Okay, fair.
Thank you. Okay.
Good afternoon, Magistrate. We're here on the town's request for authorization to foreclose a code enforcement lien on the property located at 80th Avenue East under code enforcement case number 14-0394. Just to give a little bit of a background on this case, this code enforcement lien arises from a violation on the property that was originally adjudicated by the special magistrate in 2016. Respondent's predecessor in title was found in violation of the code in order to bring the property into compliance within a set time frame and failed to do so. As a result, a daily fine of $250 per day accrued and a lien for the fine was recorded against the subject property. This lien was the code enforcement order to impose lien, which was recorded April 12th, 2016 as instrument number 2016-000076-125, and that's attached as Exhibit B to the notice of hearing on page 9 of the agenda materials. The special magistrate previously authorized foreclosure, which I'll get back into in a moment, but by 2019 the property had a new owner, Mr. Orlandini, who's another of respondent's predecessors in title, and the property remained in violation. Because the violation continued on the property, the special magistrate entered an order certifying that a fine of $250,150 had accrued and continued to accrue in the amount of $250 per day for each day the property remained out of compliance. And this instrument is the code enforcement order imposing lien, which was recorded again as a lien against the subject property, as well as all other real and personal property owned by Mr. Orlandini, and this was on March 27th, 2019 that it was recorded. And that instrument number was 2019-000-067-137. And that order is attached as Exhibit A to the notice of hearing, and that starts on page 6 of the agenda materials. And this is the instrument that we're asking to foreclose today. The town previously came before the special magistrate in February, on February 12th, 2024, to request authorization to foreclose the lien in this code enforcement case. And we've since become aware of a clerical error by staff, which resulted in Your Honor authorizing foreclosure of the order that was recorded on April 6th, 2016, instead of the lien that was recorded April 27th, 2019. The town is not pursuing foreclosure of that April 12th order, and so we're here today to request the foreclosure of that code enforcement order that was recorded on March 27th, 2019. And again, this is Exhibit A to the notice of hearing in the agenda materials, and we're not requesting any changes be made to the previously entered order authorizing the foreclosure on that other lien.
You're not?
No, just a new order authorizing foreclosure on this particular instrument, which that's the number that ends in 67137. With that being said, respondent, White Sand Properties of Fort Myers Beach, is the current owner of the subject property, as reflected by the Lee County Property Appraiser's website. Screenshot of the Lee County Property Appraiser information for the subject property is on page 39 of the agenda materials. And notice of this hearing was provided to the respondent, and a copy of that notice can be found as Exhibit A, pages 4 through 13 of the agenda materials. And the notice of hearing had 3 attachments. The code enforcement order imposing lien, which was recorded on March 27th, 2019. That's the order that we're requesting authorization to foreclose at this hearing. That previously entered code enforcement order that was entered April 12th, 2016, and the town's proposed order for today's hearing. Regarding satisfaction of the notice requirements, I have Code Enforcement Manager Yazo, who submitted an affidavit of notice and posting attesting to complying with the notice requirements. And I also have an amended hearing Exhibit B. This was amended as to the order of the attachments, if I may approach to provide you with that, and I have copies for everybody else.
Yeah, make sure you hand counsel a copy and you give her.
Yes, Your Honor.
Thanks.
And I defer to Code Enforcement Manager Yazo to present the information contained in this affidavit.
Good afternoon, Your Honor. My name is Thomas Yazo. I'm the Security and Compliance Manager for Fort Myers Beach. I've been employed here for approximately 2 years. I took over my current position March of 2024. I'm presenting today the affidavit of notice and posting. You'll see within that notice, which is in the exhibits, where we posted those properties to, or posted with certified mail and how it was done. First was sent certified mail to White Sands Properties, Fort Myers Beach, LLC, 3210 Sterro Boulevard, and that's the property address. Second was Stephen Romuni, apologize for pronouncement on the name, he's the registered agent, at 110 North Main Street, LaBelle, Florida, 33935. The third is C, White Sands Property, Fort Myers Beach, LLC, P.O. Box 1118, LaBelle, Florida. That's the mailing address. And the last would be White Sand Properties of Fort Myers Beach, LLC, 415 Palermo Circle, Fort Myers Beach. Copies of the certified mailing receipts are attached in Exhibit B. I posted a notice of the same at 80 Avenue E, Fort Myers Beach, which will be exhibited in C, shows photos of same. They're true and accurate copies of those photos. I posted a copy of the notice at the Primary Municipal Government Office, Town of Fort Myers Beach, at 2731 Oak Street. And again, true and accurate photos were posted in Exhibit D. In addition, they were also posted to the town's public accessible 24/7 website, which is listed here as Exhibit E.
And Your Honor, while I have Mr. Yazo here, I'd also ask him to testify to another affidavit, which I have copies of as well. And let's see, this is an affidavit of compliance, which he signed, which attests to the amount owed under this code enforcement lien. That says code enforcement case number CE 140394 will be closed upon payment of $594,650, and I would just ask that he confirm that that's still the amount owed under the lien, and then I also have copies for everybody of this affidavit of compliance.
Your Honor, again, Thomas Yazo, Compliance Security Manager, Fort Myers Beach. That is a true and accurate description of the affidavit that I presented. At that time, it showed that the property was in compliance as of the 28th of September 2022 due to Hurricane Ian and the property being totally demolished as of the hurricane. This was done as desktop investigation from paperwork here in the town of Fort Myers Beach. All these are based upon my review of records at that time.
Thank you. The statutory prerequisites for foreclosure of this lien have been met. Section 162.09 sub 3 provides after 3 months from the filing of any code enforcement lien which remains unpaid, that's been recorded, the code enforcement board may authorize the local governing body to foreclose on the lien. And this lien was recorded in the Lee County Public Record more than 3 months ago. That's clear on the stamping across the top of the lien, which shows that it was recorded in the Lee County Records March 27th, 2019, again as instrument number 2019-000-67137. As such, it's clearly been more than 3 months since the filing of the lien, and the town has met its burden to foreclose on the lien. Obviously, we're here today because this lien remains unpaid and the town has not received payment of the amount due under that lien, as Mr. Yauzer testified. And also at a previous hearing to authorize foreclosure of the code enforcement lien in this case, Your Honor found that respondent did not present sufficient evidence that the lien was ever paid, satisfied, or otherwise released. And I also have copies of that prior order for your reference.
Thank you.
And I'd ask that Your Honor accept the exhibits I've provided as well as the agenda materials into evidence.
Are you providing this order as Exhibit I?
Yes, it was pre-marked as Exhibit I, based on this is attached to a complaint for foreclosure of the other lien. But yes, it can be Exhibit I.
I'll admit all these exhibits that you've provided. Is there any objection to any of the exhibits as far as, okay, then I'll admit them.
Thank you, Your Honor. And given the foregoing, we just ask that you grant the town's request to authorize foreclosure of the code enforcement lien in this case, which is the one that was recorded on March 27th, 2019.
Okay,
Thank you, Your Honor.
thank you.
Good afternoon.
Good afternoon.
So I want to start with the notice of hearing that was provided to Your Honor. And the notice of hearing, contrary to what counsel has said, is not an authorization to foreclose. If we look at it, it says it is a notice of hearing to correct clerical error in foreclose authorization order related to lien encumbering 80 Avenue A. Now, Exhibit I that you received from the town is that order they're asking you to correct. The problem with that request, at least facially, is this. The Exhibit I is a final order. And jurisdictionally, final orders can only be corrected within the time for rehearing. And under section 2-428 of the town code, which contemplates rehearing and appeals, it says that request for rehearing must, 1, be in writing, and 2, must be made within 10 days of the date of the order. So Your Honor entered this order on February 23rd, 2024. We are now about 220 some odd days past that rehearing period. And so just facially, as noticed, this is a rehearing request that is untimely and should be denied, just based on that. Second, we need to ask ourselves first, is this a clerical error? And to understand that and why the answer to that is no, I want to go back to the original notice of hearing that produced Exhibit I and walk the court through why this was a substantive issue and not a clerical one. am gonna provide to your honor, and I'll have copies for counsel, is I'm gonna mark this as Defendant's Exhibit 1, if I may.
Thank you.
Thank you. Do you have a copy for?
Yeah.
Thank you.
So the first page there, Your Honor, just kind of a demonstrative to illustrate what you're gonna see when we walk through this. But we're really focused on CE 14-0394. And you'll see the instrument number there is the one ending in 76125. That is the lien that was reported on April 12th, 2016. Now you'll see in the amended and corrected notice of code enforcement hearing there that the town requested to foreclose on certain liens. Now, of those 3 liens mentioned on the first page of the notice, only one of them is actually correct. That's the 2019 000160404.
Your Honor, I object to him bringing in the other code enforcement cases into this hearing, as this is just a hearing on concerning code enforcement case CE 14.
I understand, but I need to hear his background, where he's going with it, so.
Yes, Your Honor.
Thank you.
So what you'll see there, though, Your Honor, is it also says a copy of the liens, or the reference liens, is attached hereto and incorporated by reference. So when we go to those, the first lien is the lien that is referencing or was sought to be foreclosed at CE 15-0167. But then when we go forward and we get to the case that we're here about today, CE 14-0394, you'll look up at the very top and you'll see that the lien at issue was the one recorded on April 12th, 2016. It's the instrument number ending in 76125. Not the 2019 lien that they want to have Your Honor's order corrected to be included in the authorization of foreclosure. So the relief they sought in their notice of hearing was to foreclose on the April 12th, 2016 lien ending in 76125. Then, when we get to the hearing that happened, I'm going to mark this as Defendant's Exhibit 2. Counsel.
Thank you.
Again, the first page there is for demonstrative purposes, but at the hearing, the town introduced a composite Exhibit B, B1 through B3. And the one that we're really looking at is Exhibit B2. That was the lien that they asked you to foreclose on. And consistent with the notice of hearing attachments, the town introduced for the 14-0394 case, the April 12th, 2016 lien, ending in 76125. So the relief sought in the notice and the evidence presented at the prior hearing was consistent. It wanted you to enter an order authorizing foreclosure on the 2016 lien recorded on April 12th, ending in instrument number 76125. And that's exactly what Your Honor's order did. When we look at the town's Exhibit I that they introduced today, you did exactly what they asked. You authorized foreclosure on the April 12th, 2016 lien, ending in 76125. When we think of clerical errors, if we were to use the analog of a 1.540 motion, we're talking about typos, not errors in substance, where it may relate to something where a litigant sought the wrong relief, introduced evidence inconsistent with what it wanted. This is not a situation where Your Honor made a typo and entered the wrong instrument number or the wrong lien. Your Honor did precisely what the town asked for, both in its notice and in the evidence presented. That's substantive. That's not a clerical error. If you were to change and correct this order, you would be giving the town new substantive relief. You'd be authorizing foreclosure on a new lien. And so, based on that as well, even if you were to conclude that this was a proper rehearing request that you could entertain jurisdictionally, it's still not a clerical error that could be corrected. It's a substantive mistake, and the relief that they're seeking based on that's not available. Depending on, and I think that's the threshold issue we need to get to before any of the other stuff, because as noticed, this wasn't an authorization to foreclose. This was we want to correct a clerical error. And so depending on how Your Honor rules on that, if we're gonna proceed forward, then I will be calling my client, but if Your Honor's inclined to say, I'm gonna hold them to the notice of hearing and just decide, is this a clerical error, then my client doesn't need to testify.
Are you prepared to testify the defense of the substance?
What do you mean?
Are you prepared to proceed beyond the threshold question?
No, because I need to have another gentleman, Joseph Orlandini, who was, as you heard counsel say, the owner of these properties at the time these liens were recorded, come to testify. And so that's evidence and testimony we would need. So I think we need to hold them to the notice of hearing, which is, can they correct this?
Okay. Response?
Yes, Your Honor. As I stated in my presentation, we're not seeking to amend or disturb the previous order entered in this case. We're seeking a new order authorizing us to foreclose on the document attached as Exhibit A to the notice of hearing. And I'll just read directly from the notice of hearing to show that this is the issue that was noticed for today's hearing. Pursuant to section 162.09 sub 3 Florida statutes and in accordance with section 2-427C of the Town of Fort Myers Beach Land Development Code, the undersigned code enforcement officer has documented that 3 or more months have passed since the lien attached to this notice as Exhibit A was recorded in the official records of Lee County, Florida. Although not legally required, a hearing will be held on Wednesday, January 29th, 2025 at 1 p.m. in the Town Hall Council Chambers before the town special magistrate to authorize foreclosure of the lien attached as Exhibit A. And that lien attached as Exhibit A is the order that was recorded March 27th, 2019. And so this was noticed as a hearing to authorize foreclosure on that particular instrument, not as a hearing to change an order that was previously entered in this case. The clerical error, just to clarify, the clerical error was the fact that the order that we're seeking to foreclose now was not included in the agenda materials or notice of the previous hearing. And so that's the error that we're seeking to correct, but it's more on our side. We're seeking to correct that error. We're not seeking to correct any error within your order. We're just seeking a new order that authorizes us to foreclose on this lien, which meets the statutory requirements of it's been more than 3 months since this lien was recorded and it remains unpaid. And I'd be happy to answer any questions if Your Honor has them.
You're saying that the clerical error was the failure to include,
The correct document that we were attempting to foreclose on, yes.
okay. And you acknowledge that the notice of hearing is titled, Notice of Hearing to Correct Clerical Error in Foreclose Authorization Order Related to Lien Encumbering 80 Avenue E?
Yes, Your Honor.
I'm gonna have you go ahead and proceed with the substance. I will not rule today. I wanna hear what your substance is, if we need to continue and reset for the next regular hearing, which is in February, for you to bring in the next witness, we can do that. And I will address all of the arguments at the same time, but I would rather just have it all.
That's fine. And the main substance of, just,
Sorry, so go ahead and proceed with the substance of your defense.
and so that, Your Honor, at the prior hearing, I'm just gonna put it out there, Mr. Ramuni presented you with some evidence of a settlement. And I don't know if Your Honor recalls that, he presented you with a check.
I do.
Okay. And if I recall correctly, Your Honor said, and I'm not trying to put words into your mouth, so if I'm misremembering, I apologize, but I think what I recall you saying was, I'm not gonna be considering that, that's whether or not there was a settlement, you could raise that in the foreclosure case that was pending at the time. If that's still the court's position, then the testimony from my client, Mr. Orlandini, that's what it's all gonna be about, why there was a settlement. And so the reason I have him here today, though, and would like to present Mr. Orlandini, is that in that foreclosure case, which has since been dismissed, the town sought to say that the issue of settlement, despite Your Honor saying you weren't addressing it, was somehow a res judicata issue that had already been determined. And so, if Your Honor is gonna maintain that same position, that I'm not considering it, if you're inclined to move forward with and consider the substance, I would say, one, just make that abundantly clear so that if we do end up in court again, we don't have those res judicata arguments being made by the town, and because it's made abundantly clear it wasn't something the court considered. But if you're inclined to consider it now, then I will be happy to put my client up here.
My recommendation is that you present your case and then let me decide what I'm gonna consider. I think my order was very clear.
I did as well, but when I get a 57-105 order or motion directed towards me saying it's res judicata and that it was considered, I hope the court as a practicing lawyer can understand why we have the hesitation that we do. But with that being said, I'll call Mr. Schmidt up and I'll ask him some questions for the court and we can go about it that way.
Thank you.
Can you please introduce yourself?
Yeah, Jesse Schmidt.
Mr. Schmidt, do you have any relationship with White Sand Properties of Fort Myers Beach?
Yes,
What's that relationship?
owner.
And does White Sand own any property located at 80 Avenue E, Fort Myers Beach, Florida?
Yes.
About when did White Sand acquire 80 Avenue E?
To my best recollection, around it was in March of 2020, I believe.
All right, now what about property located at 1560 I Street here in Fort Myers Beach? Does White Sand own that property?
Did on that property. It's been sold.
Okay, well, when did White Sand initially acquire?
I
I Street.
believe December of 2019.
Okay, now, who did White Sand acquire 80 Avenue E from?
Joseph Orlandini.
And what about I Street? Who did White Sand acquire?
Joseph
I see.
Orlandini.
Mm-hmm. Now, how was it that White Sand came to acquire 80 Avenue E from Mr. Orlandini?
Mr. Orlandini was behind on his note and he was in foreclosure and wanted to sell it.
All right, now, did the acquisition of 80 Avenue E have any relationship with White Sand's purchase of the 1560 I Street property?
Yes, 1560 was Joe Orlandini's house also, and the fines that were on 80 Avenue E had encumbered all of his properties at that point.
Okay, so when was it that White Sand decided it wanted to try and acquire the 1560 I Street property?
Probably about, I signed a contract 10 months prior to closing the property.
All right, and that closing was on approximately March
It
twentieth,
was
two
March,
thousand twenty?
yeah. I said December, I think it was March. It was the beginning of March, yes, correct.
In 2020?
Yeah, 2020.
All right. So when White Sand initially entered into that contract to purchase 1560 I Street, did it know about any of those liens that you just referenced?
No,
How was it that White Sand came to learn about those code enforcement liens?
they're a title search.
Okay. So once White Sand learned about those code enforcement liens, what did White Sand do?
Went and talked to Roger Hernstead, was the town manager at the time, and made a deal with Roger Hernstead to get Joe's fines off of 80 Avenue E, which encumbered 1560 I Street. And then I went to an actual town meeting to the town council and presented them with an offer. They accepted it. I wrote the check, they cashed it, and then I closed I Street.
All right, so what was the amount that the town agreed to accept in resolution of those code enforcement liens?
$65,000 at the time. I paid 50 of the 65,000 to the town of Fort Myers Beach.
Who was to pay the other 15,000?
Joe Orlandini.
All right, was that $15,000 paid?
It was paid and then some, yes.
Okay, how was that $15,000 paid?
I bought another property from Joseph Orlandini at 1710, 1740 Estero.
And is that property called Mojo's?
Yeah, it was where the Mojo's restaurant was, correct.
All right, and so the payment of that lien, did that occur through the closing on the Mojo's property?
Correct, through a title company.
Okay. And about when was it that White Sand closed on 1710, 1740, the Mojo's property?
It was after 1560 and 80 Avenue E.
About June of 2020?
Correct, it was a few months after, correct.
Okay. For council. Mr. Schmidt, I handed you a document we're marking as defendants. I think it's Exhibit 3. Do you recognize this check?
Yes, I do.
What is that check?
That check is to resolve the liens at 80 Avenue E, and it give a partial release of Joe's fines so he could sell 1560 I Street.
Okay.
Because 1560 didn't have any liens, except for the blanket lien that was from 80 Avenue E.
So, when was this check dated?
12/12/2019.
Was that after you went to that town hall meeting that you testified about earlier?
Correct.
Was that meeting that you testified earlier on December 9th, 2019?
Correct.
Okay. Was this check cashed by the town of Fort Myers Beach?
Yes, it was.
Okay. So, do you have any relationship with Schmitty's Machinery?
Yes, I'm the owner.
Okay. So, if this was something that was being done for White Sands, can you explain to the magistrate why you wrote the check for Schmitty's Machineries?
Because Roger needed it that day.
After that check was paid to the town of Fort Myers Beach, was that lien released?
On 1560, yes.
Yes. Okay. Now, were there any other properties aside from 80 Avenue E and I Street that were supposed to be released? in conjunction with this agreement.
Yes, correct, for Joe.
Yeah.
Joe had 2 or 3 other properties.
Can you tell us what those other properties were?
One was in I don't know if it was Bay Shores, there was another one at 2890 Seaview, Seaview Street here in Fort Myers Beach. There's probably 1 or 2 more, cause Joe still owned quite a bit of property at that time.
Was 1710 and 1740?
1710, 1740 Mojo's correct.
Okay. Hand you a couple of documents here that we're gonna run through. All right, the first one is, can you identify what this document is? I believe we have this marked as defendants 4. All
Yes, partial release of land.
right, for which property?
It says 1567 I Street, but it's supposed to be 1560 I Street, I believe.
All right, and what's the date of that?
Well, nothing's been passed, it's 1/10/2020.
Say that one more time.
1/10/2020.
So shortly after the payment was made by you on the I Street property to the town of Fort Myers Beach, right?
Correct.
Okay, what is this document here that we're looking at?
It's a partial release of lien.
And what's the legal description of this partial release of lien?
Lot 10, Block D, Venetian Gardens.
As per-
As per plat there, recorded in Plat Book 6, page 70 of the Public Records of Lee County, Florida.
Is that the legal description for 1710, 1740, the Mojo's property?
I believe so, yes.
All right, and what was the date that this partial release of lien was recorded?
November 12th, 2020.
Okay, so when was that recorded in relation to when you closed on the 1710, 1740 property?
Months later.
After the $15,000 was paid?
Yes, I believe there's a substantial amount more paid, but yes.
Okay. How much was paid in total?
To my best recollection, I believe it was around 130,000.
And what is the code enforcement case number that that's in?
case number CE 17-0065.
Next one I want to show you is, we're gonna have this one, what's the date of this lien, of the recording?
March 2nd, 2021.
And what property is this concerning?
2890 Seaview Street, Fort Myers
Alright.
Beach.
Now, what code enforcement case number is this release a lien for?
Case number CE 14-0394.
The one we're here today about?
Correct.
Now, is it under your understanding that all of these liens that we've marked as defendant's exhibits were filed based on the settlement agreement that White Sand, Mr. Orlandini, and the town of Fort Myers Beach had to resolve the liens based on 80 Avenue E?
Yes, that's correct.
Once you acquired 80 Avenue E, did you make any requests of the town with respect to zoning?
Yes, I did a ZBL.
Maybe 8.
Mr. Schmidt, do you recognize the document that we have marked as Defendant's Exhibit 8?
Yes, I do.
What is this letter?
It's a ZBL zoning verification letter.
Okay. And to whom is it addressed?
White Sand Properties of Fort Myers Beach.
True and accurate copy of the letter that you received?
Yes, it is.
What's the letterhead of this?
FMB, Fort Myers Beach.
Now, if you could, I want to direct you to the bottom of the letter on page 1. Does this letter say anything about code enforcement cases?
Yes, it does. It says there are no active code enforcement cases on this property.
Why were there no active code enforcement cases on this property?
Because the liens were paid.
There
And
was-
it was brought into compliance.
It was settled?
Yes, it was settled. It was brought into compliance. This was done years ago.
And what's the date of that letter?
November 18th, 2020.
So this was dated after you had closed on 1710, 1740,
Correct.
after the monies that Mr. Orlandini were supposed to pay.
Correct.
But did the town ever actually record a release lien as it concerned 80 Avenue E?
Not that I'm aware of.
Did you reach out to the town about that failure to file a lien?
Yes.
Thank you.
The document that we have marked as Defendant's Exhibit 9, do you recognize this document, sir?
Yes.
What is it?
It is me reaching out to the town council
What are you reaching out to the town council about?
to get a lien release for 80 Avenue E.
Can you identify for the magistrate your email address on this?
Yes, it would be the sales@schmitty'smachinery.com.
All right. And who responded to this email?
Karen Woodson,
What's Miss Woodson's capacity? Do you know her
she's
affiliation?
a town council member.
And what's that say on her signature block?
council member.
And what did
Town of
Miss,
Fort Myers Beach.
and what did Miss Woodson say in response to your email?
Thank you, Jesse, for reaching out. I see that you copied Andy Hyatt, our new town manager, on this, and I will follow up with him as well. We are working very hard to clean up the past, and this is another prime example. Thank you for bringing this to the entire council's attention.
What was the past that was needing to be cleaned up here?
I had bought other properties in the town of Fort Myers Beach that had never had liens released, that were paid months and years ago also, that we had to tried to get cleaned up.
Now I'm gonna show you another email that we're marking as Defendant's Exhibit 10. Can you identify that for the magistrate?
Yes, as an email to Dan Allers.
All right. Same email that Ms. Woodson just responded to?
That's correct.
Okay, now, what was Dan Aller's response?
Good morning. I have added our town manager, town attorney, and director of operations on my response. Becky and Andy, what can we do to resolve this as soon as possible? This was an issue before I came on council and thought it was handled years ago,
Why would it have been handled years ago?
because it was handled years ago.
And can you explain what exactly the handling would have been?
Whenever Joseph Orlandini and myself, after I'd put 1516 under contract, I found out Joe not only had beach liens, he had IRS liens. He had investor liens, he had bank liens. So it took 10 months to try to sort that out before I could even get to the council, or before I could even get to Roger Hernsted for 80 Avenue A to release the liens. And that's why I had to go to the town council and pay the $50,000.
And then Mr. Orlandini also had to pay his
Correct.
share of it.
Yes.
So it was all resolved,
It was all resolved years ago.
and that was because you guys had a settlement.
We had a settlement with Roger Hernsted, and Roger Hernsted said as long as the town council approves it, it's all done and over with.
And-
The town council approved it, I believe, I wanna say it was in maybe December, but I can't remember.
December of what year?
19, I think.
Mm-hmm.
So, I mean, it's been 5, 6 years ago. It's been a long time.
Okay. That's all I have for Mr. Schmidt. There is one more document I would like to, however, provide.
Eleven.
11.
I'm sorry, before you let your witness go, do you have any questions for this witness? And I'm sorry, do you have any questions for this witness?
Yes, sir.
Okay, could you please come back up? Sorry about that.
Mr. Schmidt, you testified earlier that you did a title search prior to closing on 8th Avenue East. Is that true?
I don't recall that saying I did a title search on 80 Avenue E, no.
So are you saying you did not do a title search on 80th Avenue East?
Mr. Remuti took care of that for me. If Mr. Steve Remuti takes care of all the business for White Properties, so I guess that would be more of a question for him.
Okay, so did you obtain a release from the liens that were encumbering 80th Avenue East? Like an actual release of those liens on the property?
No,
Okay, and you agree that the partial releases that your attorneys provided, all of those are titled partial release of lien?
Yes, it was 65,000, I paid 50 of the 65,000, correct.
Okay, and going back to the check that you've provided, do you have a copy of that?
I can get a copy of it.
Okay, I have a copy here for you.
Sure.
Can you read the memo of that?
It's partial release for 1560 I Street, correct.
Okay, and that, you agree that that says 1560 I Street and not 80th Avenue East?
The reason this is 1560
Please
I
just answer
Street-
the question.
Okay, what was your question?
Do you agree that that says 1560 I Street and not 80th Avenue East?
Correct, because that was the property I was buying at the time.
Did you ever write another check, other than this one, for the release of the liens on 80th Avenue East?
Not myself personally, no.
Okay. Earlier you testified that the town council said as long as town council approves the settlement agreement, that it would go through. Do you have the minutes from that town council meeting?
I believe I stated Roger Hernstead said as long as the town council approves it, that, yeah, and I believe we can get that correct. It should be public knowledge.
Okay, so is there any documentation of the town council approving this supposed settlement that you're claiming settled all of the liens on 80th Avenue East?
I had to go, like I said, in front of the town council to get 1560 released because it was under, all of his properties was under Orlandini Properties or Joseph Orlandini, and the liens from one property encumber all of his properties, not just, the liens just don't stay on one property, they encumbered all of his properties together. 1560 had no liens on it at the time that I purchased it, as far as violations from the town. But 80 Avenue E carried over onto his other properties.
Right, and you agree these partial releases that were recorded, the one I'm looking at is the one for code enforcement case CE 17-0065, for example. But can you read that bottom line there on that lien?
This partial release of lien releases only the property mentioned herein. All other properties attached as a result of DOC type LI instrument 2019-000160404 remain.
Okay, and so you agree that means that the property, this 1560 I Street was released from this lien, but do you agree that this states that all other properties encumbered by this lien remain encumbered?
That's why Joe had to pay the 15,000, correct? To get the rest of them released.
Sorry, what exhibit are you referring to?
I don't have it marked on mine. It was the stack of partial release of lien that I was provided. Perhaps council can help me with what number that was.
Which one is it? I can tell you.
Okay, so the specific lien I was looking at is the partial release of lien releasing 160404. At the top, that's instrument number 8482, ending in 8482.
4, exhibit 4.
Yeah.
Was there ever a written agreement entered into that would have memorialized this supposed settlement?
Yes, there was, with Roger Hernstead and Joseph Orlandini. I
Where-
sat right there at the town hall and did it with them.
Where is that agreement?
You'll have to ask Roger and Joseph Orlandini. I wasn't the owner at the time, so Roger would not give me a copy.
So you never requested a copy of the agreement?
Yes, I
that-
did. I did request a copy. I requested a copy several times, and since I was not the owner of the property, Roger Hernstead would not give it to me.
And so you're saying that without having a copy of the agreement that memorialized that these liens would be released, you still purchased the property knowing that they were encumbered by these liens?
The liens were paid at that time.
The liens in the public records of Lee County, again, if you had a title request, the records would have shown that these liens were still encumbering 80th Avenue East.
I guess my question would be, how did he sell the rest of his properties without paying them liens then?
Well,
It-
that's
it-
not what we're here to
well, I mean, it
determine
would've been
today.
possible, I think.
I have no further questions for this witness, but I would like to recall Code Enforcement Manager Yazzo.
Hang
In
on,
a
do you have any
moment.
follow-up questions for your client?
No, I do wanna get to that other document.
Sure, yes, but before we proceed to that, do you have any follow-up questions?
No.
Okay.
So. Start moving and then.
Yeah.
That one doesn't have the pretty sticker on it, I apologize. Yeah, let me show that to council real quick though. All the paper we've been shuffling. Council. So we're gonna be marking as exhibit 12. I just need you to look at it so we can introduce it. Okay.
Yes. Yeah, whoa,
Oh, did I already pass that on?
I don't know, hold on, let me check if it's the same.
I have a black and white copy of it that I was.
It looks like it's the same.
Does it have the red circle on it? Cause there's two of the same letter with the one difference being it's attached to the email. Okay, it's the same.
So you have it marked as 11.
Okay, then I don't need that.
Okay, thank you.
I thought I maybe passed it out, but once things start moving. So, Your Honor, you'll see there, this is another email from Councilman Woodson attaching that November 18th, 2020 letter where she circled in red the no active code enforcement cases on this property. And she obviously was expressing concern about that and about whether that document had been considered in the decision-making process on 80 Avenue E. And that email was sent to the town council on May 10th, 2024. And with that, our, subject to us continuing to February where I can call Mr. Orlandini, council can recall her witness if she so desires.
Okay. With this is,
Yeah, I mean, I have some argument to present, but obviously I think you would want the evidence to conclude, I suspect, right?
if you wanna
Present the evidence? or the
complete what,
argument?
yes, complete your presentation.
All right, thank you then. So I think what you've heard from Mr. Schmidt was.
Can you go
Bill?
to the microphone, please? Sorry.
What you've heard from Mr. Schmidt was that there was an agreement in place between White Sand, Mr. Orlandini, and the town for the liens on 80 Avenue E to be released in exchange for $65,000. Mr. Schmidt explained that initially, he paid that $50,000 up front. The remaining $15,000 was to be paid by Mr. Orlandini. That $15,000 was paid after Mr. Schmidt and Mr. Orlandini closed on the 1740 property, which is where Mojo's is located here on Estero Boulevard. And that once that occurred, all the properties encumbered by that lien, aside from 1560 I Street, which had already been released, were to be released. And those series of release of liens that we introduced as exhibits show that was what occurred. That Seaview, one of the properties Mr. Orlandini owned, got released. That the Venetian Garden legal description that Mr. Schmidt identified as being the 1740 Estero Boulevard was released. And that because of that, really what happened here is the town just forgot to file the release for 80 Avenue E. And it's pretty understandable why when we look at the timeline of this. The closing, according to Mr. Schmidt, of the 1740 case happened in about June of 2020. At that time, we were in the full height of COVID-19. And so it's quite understandable then that the town may have had an oversight in getting certain releases filed. Indeed, you will see that the first release filed after that June 2020 closing did not actually get filed until November, 5 months later. And then the other releases, aside from I Street, didn't get filed until March of 2021. So the town was acting, it just because of the disorganization caused by the COVID-19 pandemic, they just missed 80 Avenue E. But the town's conduct in filing these releases of these other properties that Mr. Schmidt testified was encompassed by this agreement that also included 80 Avenue E shows that, as does that November 2020 letter. Remember, at that time, according to Mr. Schmidt's testimony, the closing on the Mojo's property, wherein that $15,000 by Mr. Orlandini had paid, had already happened 5 months earlier. And what did the town say in that letter? It said there were no active code enforcement cases. If there were no active code enforcement cases, that the reason for that is the properties were released, there was a settlement in place. If there was no settlement in place and these fines were continuing to accrue, as the town is now alleging and asserting, then those code enforcement cases would have been active. They wouldn't have said that. And that's why you have Ms. Woodson's email from May of last year, where she even circles that in bright red and says, like, did we consider this? That's a problem. And then when you overlay that with the emails from Ms. Woodson and specifically Mayor Allers, where he says, I thought this was concluded a long time ago. I thought it was concluded a long time ago because based on what the agreement was between Mr. Schmidt, Mr. Orlandini, and the town, it was concluded years ago. The only document that hasn't been filed is that release of lien for 80 Avenue E. Every other property that was encompassed by those liens, that was part of the agreement, has been released. One in which was the 2014 code enforcement case that we're here today on. So the town's conduct and what its actual officials have said shows that this was resolved. There were no active code enforcement cases as of November of 2020 because there was a settlement. The town's mayor thought this was done years ago because it was. And like Mr. Schmidt was saying, there's a reason that he's been able to sell these properties subsequent to his purchase of them, because these liens weren't encumbering them. You can't sell a property when there were liens on them. It doesn't make it, that couldn't happen. So it's just as a practical matter, the notion that these were partial releases as opposed to the property being released as a whole, which is what it was, just doesn't make any sense. So again, no authorization to foreclose should proceed. case that we're here on has a release on it of the lien. There was a settlement agreement in place, and it's been resolved. Thank you.
Thank you.
I just wanted to recall Officer Yazzo to speak as to the continuation of the code enforcement case on this property. Again, can you please confirm the date that the code enforcement violation in this case was actually deemed to have been corrected? And the property was deemed to be in compliance with the code under this code violation?
So due to a desktop investigation, it did show that it was shown to be in compliance as of the 28th day of September 2022 due to Hurricane Ian and the property being demoed at that time.
Thank you.
And if this property had been brought into compliance prior to that date and the fines had stopped accruing, those documents would be in your records, correct?
That's correct. I can't speak to those documents at this time because they're not in front of me. I'd have to do another desktop review to go see any of those documents that are being spoken about at this time, and I can't speak to any letters that were sent out that I had no piece in.
And can you confirm that you were not the one who sent out the letter that said there were no co-enforcement case?
That is correct. I did not work for the town at that time.
Thank you, Your Honor.
Thank you.
Can I ask one question of
Yes.
Mr. Yoso?
Yes, sir.
Just come up here real quick with you.
Please do.
Yeah,
We're good.
we can share. Hurricane Ian, did White Sand get a permit for Hurricane Ian?
I can't speak to that. I didn't work here during Hurricane Ian, so I don't know if there was a permit for Hurricane Ian. Correct.
Yeah. No.
Can I just ask him one more question? No?
Are you referring to the permits for Hurricane Ian?
Yes, I just would like to have on the record, if Mr. Yazoo could confirm whether his office is the office that issues permits.
Your Honor, I'm gonna object. They've had their chance to redirect, and, I mean, they've already reopened. I mean, I think that's improper.
It's fine. It's okay. I don't need that.
Okay.
Thank you. I do have one question. You had stated that there was a discussion of the settlement during a town council meeting. Is that correct?
Yes.
Which town council meeting? When was that?
So, yeah, I mean, Mr. Orlandini can testify that too, but it was December 9th of 2019.
I'm just wondering if you have that information.
Yeah, December 9th, 2019.
Okay.
Yeah. I actually have the minutes, if you'd like them.
Do you have any objection to the introduction of the minutes?
No, Your Honor.
Okay. Can you provide council a copy first?
I think I can manage that.
12.
Back up, okay.
What number are we on? 12? Okay.
And just so Your Honor knows, the highlighting on there, that was produced in discovery in the foreclosure case. That's not my highlighting.
I'm gonna admit all of your exhibits, okay?
Thank you.
Okay, so here's what I'm gonna do. I will issue an order within the next 15 days regarding the threshold issue, okay? Depending on how that turns out, I would just wanna take a look at the notices and the history, just to make sure that we get that threshold issue, because you're right, that is a threshold issue that has to be decided. You do understand, though, that regardless, I mean, if it has to be properly noticed, this is still an issue that can be brought in a separate hearing, just with a different notice, right?
Just want it to be done correctly.
Okay, and I totally understand and I agree, I'm just saying that, you know, we'll be right back in the same, potentially in the same situation. I do agree that the notice is confusing, because it does have substance of foreclosure, but part of the substance is also not. It's a clerical error that it says that it is to be corrected. So the substance of the actual notice includes both. So I just wanna take a deeper dive into it before I make that decision. I will then, obviously, if I decide that it is not properly noticed and there is a jurisdictional issue with that, that would be the end of this. The order, they would not be continued, because there would be no reason to, unless it gets, you know, you would have to renotice it for a separate hearing if you wanted to proceed. If, on the other hand, I think the notice was proper, we will continue this to the March 5th, because the February one is too soon from now. So I want to give the parties sufficient time to prepare. I understand you have one more witness that you wanted to present. During that time, if you want to prepare briefs, that is always going to be helpful, before that March 5th hearing.
Would the court like briefing on the threshold issue as well? Because I'm happy to provide that.
I mean, if you do, I would ask that you do it within the next, what are we, Wednesday? Because I would need to give you sufficient time, and then I would need to give the town sufficient time to respond. Are you saying you want to brief the issue?
I'm happy with providing cases, even if it's not a full briefing. I just wanted to offer it to the court in case you wanted it.
Do you want the opportunity to brief the issue?
If he's going to submit anything, I'd like the opportunity to respond to what he's submitting.
Of course, I'm saying,
No, if he's not gonna send anything, in, I don't need to brief him.
would you be able to have it by Friday the 31st?
I can't, because I'm supposed to be up at a conference in Orlando on the 31st. And I'm part of the leadership for that conference.
If you would, how much time would you be proposing?
Can I get it? February 4th?
That's Tuesday.
Yeah. And the only reason for that is I got the conference on the 31st, and I got a summary judgment response in the Northern District of Florida due on the 3rd.
Okay. The 4th, and then the Friday the 7th, is that sufficient time to respond?
Yes.
Okay. All right, so we'll do that. Any supplemental materials or brief the 4th, and then I'll provide the town until the 7th to reply.
Thank you, Your Honor.
Okay, pending the outcome of that, depending, you know, if we need to continue then this hearing, we'll do it for the March 5th hearing. Okay.
How should we submit the briefing?
It could be submitted to the clerk.
Email?
Amy, AMY, @fmbgov.com.
Thank you.
Okay. In the meantime, there's nothing stopping the parties from actually talking and sorting it out, because it seems like an exchange of information might be helpful to the parties. Which then, if we do continue the hearing, or if this hearing were to be re-noticed for, you know, a different type of hearing, it would be helpful, at least if the parties, I don't know, maybe talked about it. It's up to you all, but maybe you can resolve it. And, well, you'll have the order from me, if I have everything by the 7th, so you'll have the order, you know, within 15 days, which then you'll know, I'll put on the order if it'll come back on March 5th or not, okay? Is there anything else to address today?
I appreciate the time, thank you.
Of course, yeah, okay, all right then. Is that it for today?